Okay, so I'm gonna reiterate a couple of times throughout the process. I mean, throughout this presentation about if you pay for this ticket at full price is $45.88. If you bought your ticket at that price, you get the replay emailed to you on November 20th for free. If you got a discounted ticket, whether it be 80% off, 30% off, whatever, if it was a free ticket, the replay will be available for sale, which is a purchase on November 20th on my website. Of course, it's always going to be a reasonable price, but with all of the information that I give you guys for such a low cost, donations, that's pretty much my price is just a donation, so that I can keep this going. So like I said, if you're just coming in, welcome in. I probably want to give people a couple more minutes to come in. I'm gonna give people about 5 more minutes to come in. I'm gonna just play a little timer on the screen to give people about 5 more minutes because I see more people coming in. And then after that, we're going to get right into it. So let me go ahead and put a timer on real quick. So like I said, I'm gonna play a 25-minute video. This video is from two lawyers who are going to be explaining how repossessions are done illegally in different circumstances. And then after that, it'll I'm gonna do the presentation, so we're gonna get right into it. People are probably still going to be coming in, but again, I'm gonna say this a couple of times throughout this presentation. If you paid $45.88 for a ticket for this event, then you will get the replay for free on November 20th. It'll be emailed to you. But if you got the ticket at 20%, 30%, 80%, whatever, or for free, any type of discounts, the replay is not going to be emailed to you for free. However, it will be available for sale on November 20th. Like I said, the cost of the content is just donation. That's why it's so low. That's why the prices are so low. So let's get right into it. I'm going to share that video now.
Hello, everyone, and welcome to our first episode of People's Law. I'm your host, Bob Coco. I've been a practicing lawyer in Philadelphia for over 20 years now, and most of that time I've specialized in the practice area of consumer protection law. My goal in this show is to improve the average person's basic knowledge of the laws that most affect their daily life. To do so, I will have guests from the legal community provide you with useful information to understand your legal rights in different areas of civil and criminal law. So the first topic we're going to discuss involves automobiles. One of the biggest purchases the average consumer makes is buying a car, the other being buying a house. In our show today, we will be discussing two consumer protection law topics related to automobiles: unlawful repossession of automobiles and used car auto sales fraud. To help us understand and discuss these issues, we'll talk to attorney Bill Bensley. Bill, welcome to the show.
Thank you for having me, Bob.
So I'd like to start out by talking about auto repossession, because even though it's something that's popularly understood to occur, I don't know that people from our own practice of the law that people know really what their rights are when these things occur. So I don't want to talk about when repossessions happen in the middle of the night, because that's not going to invoke legal rights as much as the topic that we are going to talk about, and that is when a consumer confronts the repossessor while the repossession is happening. So let's talk about that. If I am a consumer and I hear the repossessor repossessing my car, what is within my legal rights to do and say if I want to confront the repossessor about taking my car?
Good question. I have to agree with you. This is a very little understood area of the law. Scary enough, that's also true of the judges. And yeah, you are the owner of that vehicle. So even if it does happen at night, and a lot of them do, and no matter where that vehicle's parked, if it's on your property, in the supermarket parking lot, on the street corner, If before the repossession agent has possession of the vehicle, you object and unequivocally tell them to stop and go away, as a matter of law, that's exactly what they're supposed to do. Now, oftentimes they will not. These agents work on a commission. They get paid per vehicle that they are able to repossess, and they have a devil of a time just finding the vehicles. So once they've located one, they want to effectuate, is the legal term, that repossession. So if you object, all too often what they will do is hurry up and hook up that car. In other words, take possession of it. So from a consumer standpoint, you're always worried about not only what rights you have, but how to enforce them. And so in this day and age, we're lucky because most people have phones that take videos or take photographs. So if this were to occur to you, the first thing you want to do is to document that you're there and you're intervening, you're objecting before this repossession, before the agent takes possession.
Okay, so let me stop you for a second to summarize what you've just said. So, number one, you can say to stop, and there's no magic words, right, to stop the conduct.
There are no magic words, but you want to be unequivocal. You want to avoid things like, well, can you just wait a second? Can you let me talk? Give me a chance to call the bank. You want to avoid that and just tell them, no, stop, go away.
Right. Don't be afraid to be bold about it.
Absolutely. Don't put yourself in harm's way, but at the same time, you have the right to tell them to no, stop, go away.
And if you have a cell phone camera, for example, to document that whole exchange.
Very important.
Okay. And does it make a difference? So you talked about the fact that the car could be in a parking lot or on someone's property. What about if the vehicle is parked on a public street? Does that change anything you've just talked about?
Doesn't change anything. Now, if they are on your property, well, there's two things. If they're on their property, and let's say you don't have an enclosed area of property, it's just a driveway or an alleyway or something like that, you can, when you tell them no, stop, go away, you should also tell them, and get off my property now. Now, beyond documenting that you're telling them this, you should all, if they persist, you should also call the police. Okay? But as you and I know, unfortunately, a lot of the police officers don't exactly know this area of the law, and there at least be some fear that they have too cozy of a relationship with some of these repossession agents, because these repossession agents have to report these repossessions to the police departments. They develop a relationship with the police department.
So you're talking about before they conduct a repossession, they often report it to the police that they're going to do it, so the police know that they're not engaging in criminal activity.
Well, some do, but I was speaking more. There is a requirement under the statute that after the repossession has taken place, that they are supposed to report it to the police department then. The idea being they don't want the police thinking the vehicle's been stolen. So when the person calls up after they get up in the morning and the car's missing, that repossession sort of already been reported to the police. Let's
talk about the police a little bit more. So sometimes, is it not true that the repossessors are the ones who call the police?
Absolutely, and that's the term we've been dancing around or referring to without actually stating it is breach of the peace. The law recognizes that a secured holder, a bank, can repossess a vehicle without a court order, without prior notice, if you're in default, but only if they do so without breaching the peace. And this term is not defined in the statute, but it has been defined in cases over the years. So anything that would potentially result in a confrontation that could turn violent is what is to be avoided.
Let's talk about some examples of that. For
Yes.
example, neighbors leaving the house while the repossessor and the consumer are having an exchange. If he's causing enough noise to have neighbors come out.
Well, even not going away, once you object and tell them not to go away, the law says, well, geez, there's an existential threat that could involve could result in a confrontation that could turn violent. So that's why they're supposed to go away. But yes, if they touch you, if they insult you, if they raise their voice, if they invade your personal space, if they block you in your door, these are all things you and I have had cases involving, shoving away from the car, trying to body or block you from the car. All of these things are a breach of the peace because as anybody can naturally imagine, that could really develop into a violent confrontation. That's especially true, as you were just, I think, intimating, where there are family members involved. We've had cases where the repossession agent gets physical with the wife, even in one case, 8 months pregnant. You can see how that could result in a reflexive, very violent response.
And that family member doesn't have to be an owner of the vehicle to have a claim against the
This
repossessor.
protection extends to everybody, members of the public, neighbors, as you mentioned, members of the family. If there's an objection, the repossessor has to go away.
What if the vehicle's taken and it's being damaged? For example, they hooked it up improperly and it's being dragged down the street and you can see parts of the vehicle coming off. Does that also create an additional claim against the repossession company?
It should. If not a claim as an unlawful repossession, it certainly should be a claim for damage and for negligence. But it probably would result in, the term of art is a commercially unreasonable act, because, of course, their plan is to sell that vehicle later and apply what they get against your debt. Well, they're not going to get nearly as much for that car if they damage it in the process. So they're held responsible for that. It's a violation of the overriding statute.
So we've been talking about the repossessor's conduct. Let's talk about the finance company or the bank that sends the repossessor out, who's financing your vehicle. And if you fall behind on payments, that prompts the repossession. Let's talk about some things that the finance company may be liable for, perhaps prior to the repossession. So, for example, if you're late on payments, I think it's popularly misunderstood. Wouldn't you agree that that you could be a couple days late, it's no big deal, they can't repossess my car, I'm only a couple days late, or I'm 1 day late, but contractually they're allowed to repossess the vehicle.
Right. No, you're right. It's a very strict law. Pennsylvania is not what's considered a right to cure state. There are some states that say before the bank or the holder tries to enforce or effectuate a repossession, they have to put you on notice and then give you a right to cure. Pennsylvania is not that way, unfortunately. So once you're $1 1 day behind, or your insurance lapses, or your car's impounded, these are all standard defaults under most contracts. But the bank is responsible for any of the repossession agent's misconduct. That's both as usually a matter of contract under the Pennsylvania statute and certainly under a couple of different Pennsylvania statutes.
What about if you're late, but you make an agreement with the bank to catch up those payments in an agreed fashion? So, for example, you missed May, but they say, okay, we'll pay half in June and then pay half in July. If they make that kind of agreement, can the bank still turn around and repossess the vehicle?
The banks would say they could. The banks would say, well, there's part of the contract that says you cannot modify this agreement other than in writing. But this happens all the time. As a rule of thumb, if in talking with the bank they're not threatening repossession, you better be worried about a repossession. They're not going to mention it because they don't want you to hide the car. That would be their fear. If they are mentioning repossession, usually they're just using that as a leverage to try to get you to make a payment. But yeah, they would be could be held to such an agreement. But this is an important part. You'd want to try to document that, either by sending them your own follow-up email or fax or text, something that brings this out of the purely he said, she said arena. Anything that's in writing that documents this contemporaneously would be very helpful to proving that agreement, which is often hard to prove. And don't think, oh, I heard that this line was recorded, so I can just get the bank to turn over that recording. Very unlikely the banks would ever turn over a recording that would be helpful to you.
Okay. And I think it's important for the audience to know that if they are stuck in a situation where they feel they've been treated unfairly or unlawfully, that if they want to call you and have you represent them against the finance company and or the repossession company, are you going to charge them any money to do that?
No, I handle all cases on a contingency fee basis, which, as you know, and we should tell the audience, means I cover all the upfront costs and expenses and then just take a percentage of whatever we are able to recover, plus the reimbursement of costs at that time, but they don't get a bill. And I think that's important. I think that's the way most consumer attorneys should work. One other thing, you mentioned, and this sort of foreshadows the next segment, that the banks being responsible. Oftentimes, when we're called about repossessions, we find out there's been fraud in the inception of the contract, so the bank had no rights whatsoever.
That's a good segue into our next segment, when we're going to talk about used car or auto fraud. So we're going to take a short break, and when we return, I'll talk to Bill about used car auto sales fraud. Welcome back to People's Law. I'm your host, Bob Coco. And to remind the audience, the aim of the show is to educate you about your legal rights in situations that occur most frequently in everyday life. Before the break, I spoke with attorney Bill Bensley about vehicle repossession. Now we're going to discuss auto fraud, more particularly used car auto sales fraud, and what you need to know when you're buying a used car and what to do if you've already purchased a bad used car. Okay, Bill, so let's talk about buying a used car from a dealer, not from a private party. We're only going to talk about dealers. So a common misunderstanding about your rights as a consumer purchasing a used car is, if something is wrong with this vehicle after I purchase it, I can't sue because I purchased it as is. So let's talk a little bit about that and what that language actually does, or what effect it has on a consumer's rights, and what effects it doesn't have, which is probably more important.
Yeah, just like as we were talking about repossession, this aspect of the consumer fraud law as is poorly understood, again, even by many judges. It's misinterpreted or misunderstood to mean buyer beware, or that you cannot make any claim based upon the condition of the vehicle. Also, there is a host of procedural hoops that a dealer must jump through before the car is even sold validly as is or enforceably as is. Do you want us to break that down a little bit?
Yeah, so even just because they say it's sold as is, and that language may appear, it still may not have the legal effect they say it has.
It almost never does. Let's start procedurally. First, even for them to make the argument the car is sold as is, first the car has to be posted with something called the the buyer's guide, under something called the FTC used car rule. It's also under Pennsylvania statute. That's the white piece of paper most people are familiar with the two big boxes. One says as is, one says warranty.
And it's applied to the window of the vehicle. It has
to be displayed prominently on the vehicle. Many times the dealers don't have it on the vehicle, and they'll slip it into the paperwork and have somebody sign it. That's not enforceable. Get your phone out, take a picture of that car when you first see it. That will show whether that it has that label on it. Secondly, on the contract itself, on the face, it has to have, there's usually several boxes, and it has to have the as-is box checked. But most importantly, and this is where most of it breaks down, if a dealer is going to sell a vehicle as is, they cannot make any affirmative representation about its history or condition or quality. The law says you can, on one hand, tout the vehicle's history, condition, or quality, on the other hand say, oh, we're selling it as is. They're mutually exclusive. They're incompatible.
Let me interrupt you there for a second, Bill.
Please.
So, because it's important that we talk about the sales presentation, which you just mentioned. So we know that as is not a bar to a consumer discussing a bad car deal that they think they've gone through. And so let's talk about how the salespersons sell the vehicle, and how they should sell the vehicle. So if you ask them a question about the car's history, and if they lie about it, is that something that's barred by an as-is representation?
It is not. And yeah, to the point, an as is, even if it's enforceable or valid, only prevents a consumer from making two very narrow types of claims: something called a breach of warranty, implied warranty for fitness, or implied warranty for merchantability. It doesn't mean that you can't claim that the vehicle was misrepresented to you in some way, that it wasn't in an accident and it was, or that it's roadworthy and it's not, or that it was not it was formerly privately owned and it really wasn't, it was a rental car, or that has various other specific problems, anything that would make the car not roadworthy, first of all. But it is not a bar to a fraud claim or to a claim under the Consumer Protection Statute. It only affects these two very narrow claims. Unfortunately, a lot of people misunderstand that it's much more broad.
So you mentioned just now accidents that occur prior to the consumer buying the car. Would you agree that this is probably the biggest problem with used car deals, and the one that, on a positive note, creates the most valuable claims for a consumer?
Well, I would agree, and not only for used cars, but for new cars as well.
Well, we'll talk about that.
Okay.
Let's stick with used cars for now.
Okay, that's your show. But yes, it's certainly the lion's share of the cases we handle. But one of the reasons for that is, again, we're talking about when you have a lawsuit, litigation, it's what can you prove. And with an accident, usually you'll have some physical evidence that this vehicle was in an accident before the car was sold. And you then can corroborate that with the records you'll obtain through subpoenas from insurance companies and so on. So it's easier to prove. Can I make a comment about the unibody structure of the vehicle? Because I think that's very pertinent to this issue.
Well, so first of all, yeah, that's obviously the frame, or what you just referred to as the unibody structure of the vehicle, is an important feature of the vehicle. And I think first let's explain to the audience what that is and why that is, and why it makes such a difference in terms of
Right.
the safety of the vehicle and the value of the vehicle that you're buying.
Right. There's no doubt if somebody tells you the car has not been in an accident, or gives you a clean Carfax, which is often the way they do it now, and it wasn't an accident and only had cosmetic damage, that will still affect the value of the car, and that's still a viable fraud action. But cars, at least for the last 2 to 3 decades, 90% of the passenger vehicles on the road have what's called a unitized frame, or most people talk of it as a unibody frame. Now, there's parts of this frame. It's a whole lattice work of welded parts. And there's parts that are called crush or crumple zones, which are made to collapse, to bend during a collision to absorb that energy. And then there's more rigid parts made to deflect that energy from the occupants. The operative problem here is that these frames are made to distort, are made to bend. These frames are made to be damaged.
To absorb the collision in an accident.
Absolutely.
To keep the occupants
and that's
safe.
true of even minor accidents, especially offset accidents where the car is hit on the corner. So you have millions of vehicles that are in what might be considered minor accidents that have serious frame damage. The tolerance for these frames in being repaired is only 3 millimeters, which is less than the thickness of 2 quarters, much less than the thickness of 2 quarters. It's less than the thickness of 3 dimes. And once these specifications are off, once the distortion is there, whether that frame will ever perform again to protect you or your family in a collision, whether the airbags will deploy, because they're based upon a certain rate of deceleration, very narrow window of deceleration on these sensors. It's an unsafe vehicle. You cannot be sure that it will perform in an accident again.
Do the dealers know sometimes when they acquire the vehicles for their sales inventory that the car is frame damaged?
Well, the most used car managers who perform thousands of appraisals of trades and so on a year will admit that they can tell a vehicle's been in an accident within seconds of walking up on it. There are just certain telltale signs that cannot be missed. They're like thunderclaps to anybody with experience.
I'm sorry to interrupt you, but we have to get a couple topics in that you mentioned. I want to make sure the audience picks up on it, because you mentioned Carfaxes, which are very popular because of the TV advertising for them. If someone gets a clean Carfax, is that a guarantee? Should they consider that a guarantee that the car has not been in an accident?
Absolutely not. Carfax has done a wonderful job of marketing their product. It's become I think, de rigueur for everybody to get a Carfax, and most dealers have to subscribe to Carfax because it's in such demand. But you're right, Carfax certainly does not capture all of the accidents. They don't have access to insurance records, for instance. They really only have access to service records and to state-based accident reports, and not all states even collect that accident data.
What about certified pre-owned vehicles? Another thing that dealerships and manufacturers promote an awful lot in advertising. Similarly to what I just asked you about Carfax, is that a guarantee to a consumer that they're not buying a damaged car?
Well, there are no guarantees.
Right, right.
And I think I've handled many certified used car cases for all the various brands, including the premium brands, and I can state with pretty solid conviction they're all scams.
Okay, I think that's an important conclusion.
Even I'll give you for instance, even with we had a recent case with a premium brand, and we got their audit records. These manufacturers are supposed to audit the dealer's operations, their operation of the certified programs on an ongoing basis, 1 or 2 times a year. And even with this premium brand, we found that the dealerships had violated the program and sold cars with disqualifying conditions in excess of 60% of the time.
Wow.
Yet they get high marks from the auditor because all the signage was good. The vehicles, many times the certified vehicles are supposed to be in a particular area of the dealer, and their numbers. There are ratios and benchmarks they have to reach in selling and offering
So the
certified programs.
manufacturers are more interested in protecting their dealers than they are the consuming public.
They make millions off these certified programs. So many of the operations guys will state explicitly that
We're running out of time, Bill. I just want to make sure that the audience listening to this segment understand the same thing that we talked about in the last segment, which is if they think they've gotten a bad used car deal, do they have to pay you for you to represent them?
I only take cases on a contingency fee basis. If they think there's a problem with a car deal, they should call an attorney. If their car's been repossessed, even if they don't know if there was anything unlawful, they should call an attorney. I would say at least 50% of the times we get a call about a repossession and there's no claim there. Upon doing some workup, we find there was fraud in the sale.
And the consultation's free too, right?
Yes, that's correct.
Okay, thanks for being with us, Bill. If you are
So you heard it out to one is an attorney, one is a lawyer. So you heard it out of their mouth that the stuff that gets done to us is illegal. So I just always like to provide a lot of proof when I share information. I don't like to leave anything out. So we're gonna get right into this slideshow. And after the slideshow is done, then I'll let everybody go. Like I said, if you purchase this for the full price of $45.88, expect an email on November 20th with the replay. If you got this ticket at a discounted price or received a free ticket, it will be for sale on November 20th for 50% off. So you can get the replay pretty much for free. I'm about to go ahead and start this presentation, and let's get into it. Welcome in, everyone. I want to thank you all for joining me today for the Repo Remedy class. I want to say really quick that anyone who has purchased this class at full price will get the replay 100% free. But if you got this class at a discount, or if you got this class for free, the replay is not free, and you can repurchase the replay 2 days after it's over. So what is that, the 20th? Or I think it's the 20th. It'll be available for sale. So let's get right into it. Repo Remedy, how to get remedy for your illegal repossessions. Intro. If you purchase a ticket to this event, you have experienced any or all of the following. I have a typo there. Recently had a car illegally repoed, wasn't given prior notice to pending repo, had a car repoed within the past 3 years, is seeking remedy for your illegal repoed car, or want to hold these corporations liable for the fraud they committed. Contracts are the necessary tool needed for businesses to lock you into fraudulent obligations. While going over most contracts, fraud can be spotted instantly. In this presentation, I will delve deep into everything you need to know to get the remedy you deserve for illegal repossessions. It's time for us to begin enforcing our rights and holding the subcontractors liable for the fraud they commit every day. Contracts. When a party fails to abide by a contract's terms via non-payment, a debtor has still rights that must be respected by creditors. These scenarios will allow you to apply your knowledge of creditor and debtor rights and responsibilities. So I'm going to be going over a number of scenarios, and they're not specifically directed toward repos, because a repossession can be done with property and other things as well. But it's just to give you guys an idea of how things can be done illegally. And then I'll give you more information on what you can do after I break down how they operate illegally. I'm just trying to get you guys to understand this whole thing as a whole. Technically, you are both the debtor and the creditor, because it's your credit that is being lended back to you with an interest rate added on it. The credit comes from your labor and your SESQV trust. However, in the case of teaching this information and how the application was completed during the transaction, you are the debtor. The finance company is the creditor. So let's get into it. The rights and responsibilities of a debtor and creditor. It's an unavoidable fact that many parties fail to perform their contractual obligations. When a party fails to abide by a contract's terms via non-payment, a debtor has rights that must be respected by creditors. This notwithstanding, there are legally permissible ways for a creditor to a debt. Creditors may be entitled to take control of assets or other things of value relating to the contract's terms. Similarly, the debtor still retains rights that protect them from harassment or criminal actions by the creditor. Although this is by no means a comprehensive list, here are a few of the rights and remedies that apply to debtors and creditors. So I'm just giving you guys a full picture of everything. If you are new to my teachings, I basically paint the entire picture and then I delve into each section separately so that you can fully understand all of the information that is being presented. I don't like to leave anything out. I tell everything the way that it's supposed to be done. So if you're somebody who has to watch a video over and over again, then the replay will be good for you, because the way that I teach, I give you a lot of information to make it all make sense. And sometimes, because the information can be so new to you, you may have to revisit the information. As I stated before, if you purchase this class at full price, the replay will be emailed to you on the 20th free of charge because you paid full price. But if you got in this class on a discounted price or for free, this replay will be available on the 20th for sale. Of course, all my prices are always very reasonable, but if you're one of those people who need to revisit this information, then I do strongly suggest you getting the replay so that you can fully understand everything that I'm going to be sharing in this presentation. Creditor remedies. If the money owed is secured, the creditor may take possession of the asset used as collateral. Now we're going to go into secured collateral. A lot of times we are under the impression that these banks or finance companies have security interest on the collateral that they are lending to us. However, most of the time they only put temporary collateral liens, or you file UCC-1s, which is having a lien on that collateral. They are only temporary so that they can get what they need to be done in the system, especially when it deals with cars. In the DMV system, they wanted to show as if there is a active lien, even when that lien has expired. So they put temporary liens that normally last 21 days on the collateral, so that we will be under the impression that they still have an active lien on the collateral. However, this is where the UCC-1 financing comes in, and that is a whole nother process in itself, but I like to bring up this because it's very important with the process that we're going through and understanding how these creditors basically use your own credit against you. Debtor's rights. A creditor is prohibited from engaging in criminal activity to facilitate the seizure of a debtor's property. A lot of times that's what they do. When they come to repossess your car, if you don't give the car up easily, that repossession person normally goes overboard to get the car repo, which is a criminal activity, especially if you get the police involved, which I'll be talking about later on in this slideshow. A creditor may take possession of an automobile that is the subject of a loan. But the creditor cannot seize the car if the debtor is physically in the vehicle. So always keep that in mind. If you're sitting in the car, they cannot take it. If they hook the car while you're in it, that is illegal. That automatically throws off the entire repossession, and you can you can file criminal charges on not only the finance company, but the repossession company as well, the tow truck company. Because all they do is employ third-party tow truck companies to do the work for them. And a lot of times these third-party tow truck companies do things basically on their own will. Because once the repossession has been put out the first time, these companies don't go back and say, oh, we taking it off. They'll keep trying to attempt to repossess the vehicle. If they're unsuccessful with repossessing the vehicle due to the fact that they may not be able to locate the car or whatever the case may be, then that is when the finance company will charge off that car. They will file a 1099-C to discharge that debt on their end, to cancel out that debt on their end, and they will win, but you will not, because it'll go on your credit, which I already been showing you guys how to get that stuff off your credit and how to get remedy for the stuff that is on your credit. And they're supposed to mail you a copy of that 1099-C that they filed. However, they failed to do that because you're supposed to file that 1099-C with your taxes. Now, I do have a 1099-C class coming up very soon for anybody who's interested. I will be sharing the information when it takes place. If you are new to my group and you have never experienced any of my teaching, you've never sat in any of my classes, you are not a part of my community, you can look me up on TikTok at I am Queen Mother 777. And also I have a private community on Patreon, which is patreon.com/divine, DIVINE, trust, TRUST, babies, BABIES. And you can go to that website and you can join if you're interested. But I'm pretty much trying to get you guys to understand all of how these creditors do us, when in actuality, we are both the debtor and the creditor. So we can control a lot of the things that we don't realize we have control over. If the subject of a contract is a mortgage, the creditor may take possession of the property and resell it. If the debtor occupies the residence, the creditor's repossession must take place in compliance with local eviction laws, which means they have to go to court. They have to file the necessary documents to get eviction started, and they have to wait 30 days before any eviction processes can take place. Scenario 1, a cosigner's responsibilities. After nearly 5 years of being at or above capacity, a local mosque is ready to expand. This planned expansion will temporarily relocate the mosque while a new facility is being built on the existing site. As part of the contract, the bank that is financing the project required 10 credit-worthy cosigners for the new mortgage. The religious community's leaders approached their members, and the required cosigners quickly volunteered cash and other assets to back the mortgage. In an extremely unfortunate occurrence, the general contractor constructing the new building suddenly disappeared, leaving the unfinished building behind. Although this was a clear case of criminal fraud, the bank holding the mortgage still demanded payment. In an effort to honor their contract with the bank, the materials for the building under the construction were sold. Unfortunately, even after the sale, the bank was still owed a little more than $15,000. Who or what entity is responsible for this balance? Now, these questions in these scenarios is just to get you thinking, before I present information with you. So these questions are not actual questions that you actually need to ponder on, but it's just to get your mind thinking. I like to exercise your mind before I teach information. What will happen if the outstanding balance is not paid? What are some of the terms used to accurately describe the events in this scenario? The creditor's remedies. Primarily, the mosque itself in its capacity as an organization, which is a private entity, is responsible for the repayment. However, if it is unable to do this, the co-signers will be obligated to do so. Note that in this scenario, the mosque sold the building materials themselves. Had the organization not done this, the bank would have had the legal right to take possession of the materials and dispose of them in whatever way was most advantageous for it. The debtor's rights. Like I said, in this circumstance, you are the debtor. So I'm giving you what both parties can do in the event. I like to be realistic with you guys. I do not want to paint any pictures like things are going to be a walk in the park or so easy. You literally have to enforce your rights. And sometimes it is a back and forth with these companies because they know that a lot of people will give up after the first or second try. But I'm showing you guys how to do a paper trail and to get what you want. The debtor's rights. Even though it owes money, the mosque is protected from certain actions by a creditor. First, a creditor will not be permitted to gain access to the property using physical force or threats of violence. The creditor cannot break into a building, drive through a fence, term. So I'm just going to give you guys some terms really quick. Criminal fraud, and this is an example in this scenario. Or in any scenario. Criminal fraud is when a contractor received payment for services that were not rendered as required. Collateral is anything of value, building materials, personal assets of the co-signers used to secure a loan. Deficiency, the amount a debtor still owes a creditor after all collateral has been applied to the debt. And default, the condition that results if a debtor does not make the required payment to a creditor. Scenario number 2, which is purge and splurge. Like a lot of startup businesses, Fix-It-Fast automotive experts wasn't going to make it. Jim, the sole proprietor, by default, had purchased some warehouse space and was in business. Also, like a lot of entrepreneurs, Jim didn't incorporate as a business. That's why it says he's a sole proprietor. A sole proprietor is someone who has not properly filed business paperwork forms to be classified as an LLC, a S Corp, or a C Corp. A sole proprietor still does everything, including filing taxes for their business expenses based off of their social security number and not their EIN number, which is nothing but a employee identification number or tax ID number. And they are basically the social security number of the business so that you can apply for things outside of being liable. When you use an EIN, you are not liable for any of the things that could happen to or for that account unless you signed a contract that held you as the personal guarantee or guarantor. And in that event, you would still be held liable. Even though you apply with the EIN, they would still collect your social security number in the event that you defaulted on the loan or whatever it is. This meant that Jim's personal assets and business assets were not legally differentiated, which is very dangerous because you never want to mix business and personal. It took about a year, but Jim's failure to do his homework and lack of business acumen caught up with him. Bankruptcy was inevitable. Jim, however, knew that foreclosure and eviction proceedings took several weeks. He also knew that some of his assets, like his expensive automotive tools, were likely to be repossessed as well. Jim thought about his financial future and decided he didn't have much more to lose. He knew that his tools, personal vehicle, and personal bank accounts were all assets that would likely be seized. Jim decided to beat his creditors to the punch. He sold all the shop's tools and anything else of value and pocketed the cash. With the multiple creditors and imminent bankruptcy, was Jim's quick sale of the tools a savvy business decision? Why couldn't Jim sell his building and pocket the cash like he did with the tools? Why were Jim's personal assets, like his personal vehicle, caught up in his business debt? Like I said, these are questions to get your gears grinding, to get your mind thinking. But it's also good for anyone who is you know, has their own business or looking to become a business or whatever the case may be, to never mix your business with your personal. The creditor's remedies. Some of Jim's creditors can and will aggressively prosecute his decision to sell his tools for cash. This isn't business savvy. It's both civil and criminal fraud. His creditors remain entitled to any proceeds from the sale of any assets he did not own outright. The creditor can file a report with law enforcement alleging that Jim intentionally disposed of and profited from the sale of things he did not own. Jim's inability to convert his building to quick cash is because his bank maintains a lien on the property for such a reason. Finally, Jim's personal assets were only caught up in this business disaster because Jim didn't incorporate his business. This means that his business creditors can and probably will seize his personal assets to satisfy his business debts. This is why it's important for you to separate the public and the private. The debtor's rights. As in the previous scenario, Jim's creditors cannot commit a criminal act to repossess property, such as breaking into the warehouse or his home. If his car is occupied and in the open, his creditors may repossess it. If it is occupied or secured in a building, the creditor must wait. That's why hiding your car in a garage can get you basically stop the repossession efforts, because they're unable to go into that garage to repossess that car. Although most of Jim's assets can be seized in this scenario, some cases have laws limiting the seizure of his primary residence and or possibly some of his retirement savings. Repossession, let's get right into it. So we're done with the scenarios. Now we're going to get into information about repossession and so on. What to know and how to protect your vehicle. If you have an auto loan, missing payments can have serious consequences, including repossession. When you finance a car purchase, the car serves as collateral for the loan, meaning the lender can take it if you default. Repossession is the process of a lender or leasing company taking back a car because the borrower has missed payments. It can happen without warning, so it's important to understand the risk and how to protect yourself. When can a repo take place? Repossession can occur as soon as you default on repayment. This means that you have missed a payment and are in violation of your loan agreement. The lender may alert you of your missed payments and attempt to collect payment before repossessing the vehicle, but they are not required to do so. In most cases, lenders can repossess your car at any time once you are in default. However, because you are protected by consumer rights, Uniform Commercial Code, and the United States Constitution, you are protected against illegal repossessions. Excuse me, guys. That was my phone. Okay. Let's get back into it. What to do if you are at risk of repo. Before you are able to seek remedy. This is what you're supposed to do before you're able to seek remedy. So if you are in the process of your car being repoed, if you've missed a payment, if you've been notified that a repossession is taking place, and you still have the car, this is what you can do before seeking remedy. These are some options. Depending on your loan agreement, you could be at risk of repossession after missing just one payment. It just also depends on the financing company as well. The best way to avoid repossession is to make all your payments in full and on time. But if you're not able to, because life happens, and you do risk repossession, before you are able to get remedy, here are a few things you can do. The first thing you can do is contact the lender. It's always good to contact the lender and let them know that you're struggling to make your payments, you're having a financial hardship, and see if they're willing to work with you. A lot of times the lender will give you options. They are very flexible when you are open with them about your circumstances. Do not be afraid to reach out to them and explain what you're going through, because a lot of times, and this is from my personal experience, when I did contact the lender when I was going through financial hardship, they would defer those payments to the end of the loan. So that way I would not be late, and it would give me more time to get the money up for the next payment. So keep that in mind. Like it says here, some lenders may be willing to defer your payments for a period of time or help you create a more affordable payment plan. They also do have that option where they'll break the payments up into bits and pieces by week, or however you are able to pay, and they'll work with you. I mean, a lot of these companies, they just want their money, right? And think about if you were if it was the other way around, you just want your money. So if a person is upfront and honest with you, you will work with them because you do see that they're still trying to pay for, their obligation. Refinance your car loan. Now, refinancing your car could really help a lot of people, but you have to have a decent credit score to be able to get a better offer than you're already under. But refinancing it could also stop your payments for a month or so, depending on what refinancing company you refinance with. If you're struggling to pay your current loan, refinancing may be an option. This involves taking out a new loan with a lower interest rate to pay off your existing loan. This can make your monthly payments more affordable and help you avoid repossession. But as I said, you have to have decent credit for you to be able to benefit from having a lower interest rate. If you don't have decent credit, it's really no point in you even trying to refinance the car, because you're not going to make out better than you already are. Consider a voluntary surrender. I don't recommend this a lot, but for some people, depending on their circumstances, this may be the best option for them, is to voluntarily surrender the car. And it also is a lot easier to clean off your credit. But if you're notified in advance of a repossession and can't find a way to cover your outstanding balance, you may want to consider voluntarily turning your car over to your lender. This can be less damaging to your credit report than having a car repossessed. But as I said, I don't really recommend that option, but I like to give you all of the options that you have on the table so that you can choose what works best for your situation. I don't know what works for you, but I do know that there's a lot of resources, and I'll just give them all to you for you to use at your own, benefit or circumstances. And keep your state's laws. Know your state's laws, excuse me. Some states require lenders to notify borrowers before repossession. So you may receive a warning before your car is taken away. Most states also have specific rules that lenders must follow, such as notifying you after the repossession and letting you know when they plan to sell the vehicle. It's a good idea to be familiar with your state's repossession laws so you can make sure your lender is following the rules, which a lot of them don't, because they employ third-party repossession companies or tow truck companies to repossess the vehicle. Once they employ them, those companies do whatever they want. You can find more information about repossession laws in your state by contacting your state's Attorney General's office. Please use all the resources that you have. It does not hurt to contact the state's Attorney General's office and ask questions. I learned from asking questions. I'm one of those people that pick up the phone and make a phone call just to get an answer to something so that I can share it with somebody else. So these are some of your options before you are able to seek remedies. So let's move forward. And not only cars are repoed. Even though we tend to perceive repossession as pertaining to vehicles, repossession applies beyond just vehicles. Typically, a secured transaction gives rise to a security interest in a property used as collateral. This is why it's important to know about the UCC, because I'm about to jump into this. Pursuant to UCC 9-109, a secured transaction is a transaction regardless of its form that creates a security interest in personal property or fixtures by contract. Even though we will primarily take a look at car repossession, the laws apply to any collateral form of security interest arising from a secured transaction. So any contract that you are under, this can be mortgage, this can be credit cards, anything that comes from a secured transaction, which is basically you borrowing back your credit. Keep that in mind. This applies to it all. Because Uniform Commercial Code, for all of my Divine Trust babies, we already know that Uniform Commercial Code is the code that governs businesses in America, right? So every business has to operate off of these principles. UCC 9-109 scope. And I want you guys to go and study this yourself, but I'm going to actually go through the whole section of UCC 9-109. General scope of article. Except as otherwise provided in subsection C and D, this article applies to 1, a transaction regardless of its form that creates a security interest in personal property or fixtures by contract. So like I said, that applies to cars, mortgages, credit cards, anything that is basically borrowing your credit back through a contract with a security interest on it, where they have collateral on what they're giving you. So this can be a loan as well. 2, an agricultural lien. 3, a sale of accounts, chattel paper, payment intangibles, or promissory notes, which has a lot to do with negotiable instruments. 4, a consignment, which is when someone basically allows you to use their credit to boost up your approval. They are also just as much responsible for that collateral as you are. 5, a security interest arising under Section 2, 401, 2505, 2711, 3, or 2A 508.5, as provided in Section 9110. And 6, a security interest arising under Section 4210 or 5118. Security interest and secured obligation. The application of this article to a security interest is a secured obligation, and a secured obligation is not affected by the fact that the obligation is itself secured by a transaction or interest to which this article does not apply. Extent to which article does not apply. This article does not apply to the extent that 1, a statute, regulation, or treaty of the United States preempts this article. 2, another statute of the state expressly governs the creation, perfection, priority, or enforcement of a security interest created by the state or a government unit of the state. 3, a statute of another state, a foreign country, or a governmental unit of another state or a foreign country other than a statute generally applicable to security interests, expressly governs creation, perfection, priority, or enforcement of a security interest created by the state, country, or governmental unit, or for the rights of a transferee beneficiary or nominated person under a letter of credit are independent and superior under Section 5114. Inapplicability of article. This article does not apply to 1, a landlord's lien other than an agricultural lien, 2, a lien other than an agricultural lien given by a statute or other rule of law for services or materials, but Section 9333 applies with respect to priority of the lien. 3, an assignment of a claim for wages, salary, or other compensation of an employee. 4, the rights of a transferee, beneficiary, or nominated person under a letter of credit are independent and superior. Independent and superior under Section 5114. You guys need to go take a look at Section 5114 because it is talking about a transferee, beneficiary, or a nominated person who under a letter of credit are independent and superior. So keep that in mind. If you go look up the definitions of credit, transferee, beneficiary, you will, and independent and superior, but definitely look at the other words in the dictionary, the law dictionary. You will realize how important this section is of the UCC 5114. Go look it up. Inapplicability of article. This article does not apply to 1, a landlord's lien or agricultural lien, a landlord's lien other than an agricultural lien, a lien other than an agricultural lien given by statute or other rule of law for services or materials, but Section 9333 applies with the respect of priority of the lien. 3, an assignment of a claim for wages, salary, or other compensation of an employee. 4, a sale of accounts, chattel paper, payment, intangibles, or promissory notes as part of a sale of the business out of which they arose. 5, an assignment of accounts, chattel paper, payment, intangibles, or promissory notes, which is for the purpose of collection only. 6, an assignment of a right of payment under a contract to an assignee that is also obligated to perform under the contract. 7, an assignment of a single account, payment, intangible, or promissory note to an assignee in full or partial satisfaction of a pre-existing indebtedness. 8, a transfer of an interest in or an assignment of a claim under a policy of insurance other than an assignment by or to a healthcare provider of a healthcare insurance receivable, and any subsequent assignment of the right to payment, but Sections 9315 and 9322 apply with respect to proceeds and priorities in proceeds. 9, an assignment of a right represented by a judgment other than a judgment taken on a right to payment that was collateral. 10, a right of recoupment or set-off, but Section 9340 applies with respect to the effectiveness of rights and recoupment of set-off against deposit accounts, and 9404 applies with respect to defenses or claims of an account debtor. 11, the creation of transfer of an interest in or lien on real property, including a lease or rent thereunder, except the extent that provision is made for A, liens on real property in sections 9203 and 308, 9308, B, fixtures in sections 9334, C, fixture filings in section 9501, 9502, 9512, 9516, and 9519, and D, security agreements covering personal and real property in section 9604. 12. An assignment of claim arising in tort other than a commercial tort claim, but sections 9315 and 9322 apply with respect to proceeds and priorities in proceeds, or 13, an assignment of a deposit account in a consumer transaction, but sections 9315 and 9322 apply with respect to proceeds and priorities in proceeds. I hope I didn't lose you guys, but let's jump into what all of that means. This is the law that covers repossessions, and that's UCC Article 9, Secure Transactions, Part 6, Default from Subpart 1, Default and Enforcement of Security Interests, 9-601 to Subpart 2, Noncompliance with Article 9-628. There are 4 main sections that will help get your remedy, including getting the repossession deleted from your consumer report. 1 is a peaceful repossession, which is no breach of peace, no protest, confrontation, etc., which is covered under UCC 9609. 2 is the pre-sale letter, which is covered under UCC 9611. 3 is the post-sale letter, which is covered under UCC 9616. And 4 is the commercially reasonably mannered transactions, which is arm's length transactions, which is under UCC section 9627. So these are the laws that cover your repossessions, and you can choose, depending on your own circumstances, which one you choose to use. So let's go deeper into it. What is a repo deficiency balance? A repo deficiency balance equals the loan balance owed on the car, which is the sale price at auction. What happens if a secured party, which is the lender, violates any of these UCC laws? Pursuant to UCC 9-625, remedies for secured parties, failure to comply with Article A, judicial orders concerning noncompliance. If it is established that a secured party is not proceeding in accordance with this article, a court may order or restrain collection, enforcement, or disposition of collateral on appropriate terms and conditions. In other words, you can get the repossession deleted from your consumer report and zeroed out, plus additional damages you incurred depending on your situation. So this is why it is so freaking important for you guys to know your laws, know your rights, because you can enforce them to get remedies that you need. Steps to get remedy. Now let's get right into the nitty-gritty. I will detail each step to take for you to get the remedy you deserve. Step 1 is to get your consumer reports. The first thing I would do is order my consumer credit reports, and you can get them free of charge at annualcreditreport.com. And the website provides free weekly online credit reports from Equifax, Experian, and TransUnion. You can pull the full report from all 3 100% free from that website. So if you don't have access to your credit report, that is the first step. The second step is to clean up your consumer reports, which I've already talked to everybody about this who attended the credit repair courses, the 3-part course. If you attended it, then you already know what you need to do. But all of this stuff goes together. This is why it is so important to have your credit together, because everything is connected. If you want to learn how to operate on both sides of the fence to get the maximum benefits in this lifetime, then you need to get your credit together. Step 2 is to clean up your consumer reports, and you're going to clean up the consumer reports as follows. First, you're going to delete all outdated info, such as addresses you will no longer use. You're going to delete old phone numbers. You're going to correct all misspellings and variations of your name that do not match how you want your name to show or how it shows on your driver's license or ID. And 4, you're going to delete any incorrect information, example, old spouse names, jobs, whatever. And 5 is to delete old employers. Step 3, you are to review your consumer reports and locate the repossession reporting. Find the repo information. Identify who is reporting the repossession. Is the repo reported by the lender, creditor, the secured party, or is it reported by a debt collector, which is a third-party information collection agency? And step 4, you're going to dispute the debt. Now, I already told you guys how you can dispute the debt, but this right here is from consumer law, and this is a good truth in lending law to use. I think it's from the FDCPA, which is the Fair Credit Debt Reporting Act. I'm probably saying it wrong, but dispute the debt directly with the person reporting the repossession. If it is a debt collector, you can't do a debt violation pursuant to 692G with cease and desist proof of. I meant you can, not you can't. You can do a debt validation pursuant to 1692G with cease and desist proof of claim, demanding to see the authenticated contract or agreement that authorizes them to collect the alleged debt from you. So you're going to make them prove to you how they're able to come at you to collect the debt. I'm gonna tell you right now, they most likely won't do that. They'll send you a letter showing you like these bogus contracts. They even may show you something that has your signature on there, but that is still not validating the debt and why you owe them. So you still have grounds to get what you need from these companies after they send you that, because that's what they're going to do. Step 2, peaceful repossession. Now we're going to go into, remember I told you there were 4 things that you can do for your repossession. So I'm going into each one separately. We just went over the first one. Now we're going to go over the second one, which is a peaceful repossession. Now, the repossession needs to be peaceful. In other words, no protests, no threats, no violence, no breaking or entering the automobile. If you are only at risk of repossession, then do not let it happen peacefully, but without putting yourself in harm's way. So make a scene, but just don't get anybody or yourself hurt. It would be enough to protest or try to prevent them from taking the car to cause a repossession to no longer be peaceful. Otherwise, was a repossession done peacefully? If not, you may have a violation of the law. If the repossession was not done peacefully, they have violated UCC 9609. Secure parties' rights to take possession after default.
I don't think you want to get in the ball pit right now.
Unusable disposition or debtor's premises. After default, a secure party, 1, may take possession of the collateral, and 2, without removal, may render equipment usable and dispose of collateral on the debtor's premises under Section 9610. B, judicial and non-judicial processes. A secure party may proceed under subsection A, pursuant to judicial process, or Step 3, the pre-sale letter. If the creditor send you a pre-sale letter, can they prove that it was sent and delivered to you? Let's see what the law says about that. Pursuant to UCC 9611, notification before disposition of collateral.
You want to keep an eye on them?
In this section, notification date means the earlier of. Please check your mics and make sure that you're muted, because I think somebody's mic is unmuted and we can hear you.
Oh, sorry about that.
No problem. All right, I'm about to get back started. The date in which a secure party sends to the debtor and any secondary obligor an authenticated notification of disposition, or 2, the debtor and any secondary obligor waive the right to notification. Notification of disposition required, except as otherwise provided in subsection D. A secure party that dispossesses of collateral under section 9610 shall send to the persons specified in subsection C a reasonable authenticated notification of disposition. C, persons to be notified. This is highlighted because this is very important. To comply with subsection B, the secure party shall send an authenticated notification of disposition to 1, the debtor, and 2, any secondary obligor. So if you have a cosigner, they want to send it to one or the other, and they don't. So this is how you can get them on the pre-sale letter. What should the pre-sale letter include? According to UCC 9614, contents and form of notification before disposition of collateral consumer goods transactions. In a consumer goods transaction, the following rules apply. A notification of disposition must provide the following information. A, the information specified in section 613(1). B, a description of any liability for deficiency of the person to which the notification is sent. C, a telephone number from which the amount that must be paid to the secured party, to redeem the collateral under Section 9623 is available. And D, a telephone number or mailing address from which additional information concerning the disposition and the obligation secured is available. 2, a particular phrasing of the notification is not required. 3, the following form of a notification, when completed, provides sufficient information, which is the name and address of the secured party and the dates. Notice of our plan to sell property. This is what the letter should say. It should have the name and address of any obligor who is also a debtor. The subject, which is going to be the identification of the transaction. It's supposed to say, we have your desired collateral, described collateral, so whatever card it is, because you broke promises in our agreement for a public disposition. We will sell described collateral at the public sale. A sale could include a lease or license. The sale will be held as follows. It's supposed to tell you the date, time, and place. You may attend the sale and bring bidders if you want for a private disposition. We will sell described collateral at private sale sometime after the specified date, A sale could include a lease or license. The money that we get from the sale after paying our costs will reduce the amount you owe. If you get less money than you owe, you will or will not, as applicable, still owe us the difference. If we get more money than you owe, you will get the extra money unless we must pay it to someone else. So if they don't send you a pre-sale letter, after they after they repossess the vehicle, then you can use this against them because that's a violation according to Uniform Commercial Code, which is the code that governs business in America. You can get the property back and this is the same letter. This is the same information from the letter, what it should say. You can get the property back at any time before we sell it by paying us the full amount you owe, not just the past due payments, including our expenses. To learn the exact amount you must pay, call us and they leave their telephone number. If you want us to explain to you in writing how we have figured the amount that you owe us, you may call us at their telephone number or write us at the secured party's address and request a written explanation. We will charge you blank for the explanation if we sent you another written explanation of the amount you owe us within the last 6 months. If you need more information about the sale, call us at their telephone number or write us at their secured party's address. And we are sending this notice to the following other people who have an interest in the described collateral or who owe money under the agreement. Names of all other debtors and obligors, if any, and then that's the end. So that is what the letter should have, the pre-sale letter should have inside of it. 4, a notification in the form of paragraph 3 is sufficient, even if additional information appears at the end of the form. 5, a notification in the form of paragraph 3 is sufficient, even if it includes errors in information not required by paragraph 1, unless the error is misleading with respect to rights arising under this article. And 6, if a notification under this section is not in the form of paragraph 3, law other than this article determines the effect of including information not required by paragraph 1. Now, step 4, which is the post-sale letter. If your repossessed car has been disposed of, here is what the law says that the creditor must do. And disposed of means after they repossess your car and sell the shit. 9, according to UCC Article 9616, explanation of calculation of surpluses or deficiency. We're going to go into the definitions in this section. 1, explanation means a writing that A, states the amount of the surplus or deficiency. All of the highlighted ones are very important. B, provides an explanation in accordance with subsection C of how the secured party calculated the surplus or deficiency. C, states, if applicable, that future debits, credits, charges, including additional credit service charges or interest rebates and expenses may affect the amount of the surplus or deficiency. And D, provides a telephone number or mailing address from which additional information concerning the transaction is available. 2, request means a record. A, authenticated by a debtor or consumer obligor. B, requesting that the receipt the recipient provided an explanation, and C, sent after disposition of the collateral under Section 9610. They don't send you a post-sale letter. It's very rare that they do. I personally have received a pre-sale and post-sale letter from Ally Financial, but other companies, they normally do not practice this. They are not, they're violating your rights. So you have 8 ways so far that you can use to get you remedy on your repo. You just have to go through this information and choose which one works best for your circumstances. I cannot tell you which one works best for you. I don't know what your circumstances are, but with me giving you this information, you're able to choose which one you want to go after based off of what matches your circumstances. B, explanation of calculation. Highlighted means very important. In a consumer goods current transaction in which the debtor is entitled to a surplus or a consumer obligor is liable for a deficiency under Section 9615, the secured party shall 1, send an explanation to the debtor or consumer obligor as applicable after the disposition, and A, before or when the secured party's accounts to the debtor and pays any surplus, or first makes written demand on the consumer obligor after the disposition for payment of the deficiency, and B, within 14 days after receipt of the request, or 2, in the case of a consumer obligor who is liable for a deficiency within 14 days after receipt of a request, send to the consumer obligor a record waiving the secured party's right to deficiency. C, require information. To comply with subsection A1B, a writing must provide the following information in the following order. 1, the aggregate amount of obligations secured by the security interest under which the disposition was made, and if the amount reflects a rebate or unearned interest or credit service charge, an indication of that fact calculated as of a specified date. A, if the secured party takes or receives possession of the collateral, after default, not more than 35 days before the secured party takes or receives possession. Or B, if the secured party takes or receives possession of the collateral before default or does not take possession of the collateral not more than 35 days before the disposition. 2, the amount of proceeds of the disposition. 3, the aggregate amount of the obligations after deducting the amount of proceeds. 4, the amount in the aggregate or by type. And types of expenses, including expenses of retaking, holding, preparing for disposition, proceeding and disposition of the collateral, disposing, of the collateral, and attorney's fees secured by the collateral which are known to the secured party and relate to the current disposition. 5, the amount in the aggregate or by type and types of credits, including rebates or interest or credit service charges to which the obligor is known to be entitled and which are not reflected in the amount in paragraph 1. And 6, the amount of the surplus or deficiency. D, substantial compliance. A particular phrasing of the explanation is not required. An explanation complying substantially with the requirements of subsection A is sufficient, even if it includes minor errors that are not seriously misleading. And E, keep pressing the button. Charges for responses. A debtor or consumer obligor is entitled without charge to 1 response to a request under this section during any 6-month period in which the secured party did not send to the debtor or consumer obligor an explanation pursuant to section B. 1, the secured party may require payment of a charge not exceeding $25 for each additional response. And step 5 is commercially responsible mannered transaction, which is an arm's length transaction. According to UCC 9627, determining of whether conduct was commercially reasonable, A, greater amount obtainable under other circumstances, no preclusion of commercial reasonableness. I can't read today. The fact that a greater amount could have been obtained by a collection, enforcement, disposition, or acceptance at a different time or in a different method from that selected by the secured party is not of itself sufficient to preclude the secured party from establishing that the collection, enforcement, disposition, or acceptance was made in a commercially reasonable manner. Dispositions that are commercially reasonable. A disposition of a of collateral is made in a commercially reasonable manner if the disposition is made in the in the usual manner of any recognized market at the price current in any recognized market at the time of the disposition, or 3, otherwise in conformity with reasonable commercial practices among dealers in the type of property that was the subject of the disposition. C, approval by court or on behalf of creditors. A collection, enforcement, disposition, or acceptance is commercially reasonable if it has been approved. 1, in a judicial proceeding. B, by a bona fide creditors committee. 3, by a representative of creditors, or 4, by an assignee for the benefit of creditors. D, approval under subsection C, not necessary. Absence of approval has no effect. Approval under subsection C need not be obtained, and lack of approval does not mean that the collection, enforcement, disposition, or acceptance is not commercially reasonable. According to UCC 9624 waiver, a waiver of disposition notification, a debtor or secondary obligor may waive the right to notification of disposition of collaterals under section 9611 only by an agreement to that effect entered into and authenticated after default. By waiver of mandatory disposition, a debtor may waive the right to require disposition of collateral under section 9620E only by an agreement to that effect entered into and authenticated after default. And C, waiver of redemption rights. Except in a consumer goods transaction, a debtor or secondary obligor may waive the right to redeem collateral under section 9623 only by an agreement to that effect entered into and authenticated after default. So please note that you need to read through your contract thoroughly. Use Black's Law Dictionary to define the words inside the contracts that you don't know the meanings of. This will help you to better navigate the information that I am giving. Let's get into remedies, which we already talked a great deal about, but now I'm going to be going into more detail as to the remedies that you have. All right, let's go. According to UCC 9625, these are the remedies for secured parties' failure to comply with Article 8, and everything that is highlighted is very important for you to use at your own discretion, depending on your circumstances and what works best for you and what you're trying to get or obtain from taking this course. Judicial orders concerning noncompliance. If it is established that a secured party is not proceeding in accordance with this article, a court may order or restrain collection, enforcement, or disposition of collateral on appropriate terms and conditions. B, damages for noncompliance. Subject to subsection C, D, and F, a person is liable for damages in the amount of any loss caused by a failure to comply with this article. Loss caused by a failure to comply may include loss resulting from the debtor's inability to obtain or increased costs of alternative financing. C, persons entitled to recover damages, statutory damages in consumer goods transactions, except as otherwise provided in section 9628. 1, a person that at the time of the failure was as debtor, was an obligor, or held a security interest in or other lien on the collateral may recover damages under subsection B for its loss. And 2, if the collateral is consumer goods, a person that was a debtor or a secondary obligor at the time of the secured party, at the time a secured party failed to comply with this part, may recover for that failure in any event an amount not less than the credit service charge plus 10% of the principal amount of the obligation, or the time price differential plus 10% of the cash price. D, recovery when deficiency eliminated or reduced. A debtor whose deficiency is eliminated under Section 9626 may recover damages for the loss of any surplus. However, a debtor or secondary obligor whose deficiency is eliminated or reduced under Section 9625 may not otherwise recover under subsection B for noncompliance with the provision of this part relating to collection, enforcement, disposition, or acceptance. E. Statutory damages, noncompliance, and specified provisions. In addition to any damages recoverable under subsection B, the debtor, consumer, person named as a debtor.
Go again.
I got something for the little.
You do what, Sam?
What's some things? Hey, what's these cards about saying?
In filed record, as applicable, may recover $500 in each case from a person that 1. Fails to comply with subsection 9208, 2. Fails to comply with subsection 9209, 3. Files a record that the person is not entitled to file under section 9509A, 4. Fails to cause their secure party to of record to file or send a termination statement as required by section 9513A or C. 5. Fails to comply with section 9616B, 1, and whose failure to part of a pattern or consistent with a practice of noncompliance, or 6. Fails to comply with section 9616B, 2. F. Statutory damages, noncompliance with section 9210. A debtor or consumer obligor may recover damages under subsection B, and in addition, $500 in each case from a person that, without reasonable cause, fails to comply with a request under section 9210. A recipient of request under section 9210, which never claimed an interest in the collateral or obligations that are the subject of a request under that section, has a reasonable excuse for failure to comply with the request within the meaning of this.
Don't lie to me, because if I come in there and stuff on the floor, you're getting whooping.
To make them come.
So you better go in there.
Hey, can y'all make sure y'all on mute? We can hear y'all. Jessica, we can hear you. Can you make sure your phone or device stay on mute, please?
You can't hear me, could you?
Not just now, but before, yeah, before I started talking, yeah, we could hear y'all.
But it says I'm on mute.
Maybe sometimes that's because I muted you, but you keep going off mute. Maybe you hitting the screen by mistake.
I'm sorry about that. I apologize.
No problem.
Because I couldn't even see the videos or header videos that was playing.
I don't know what kind of device you're on, but you probably gotta look at your settings.
Okay.
Subsection. And G, limitation of security interest, non-compliance with section 9210. If a secured party fails to comply with a result regarding a list of collateral or a statement of account under section 9210, the secured party may claim a security interest only as shown in the list or statement included in the request as against a person that is reasonably misled by the failure. So, this is why I said the information that I'm giving you guys, you literally have to do your due diligence and go into these sections and see which one of these work for your specific circumstances, because I'm giving you all the information that you need to be able to handle getting the remedy that you deserve from any type of repossession with all this information. But you have to go and do the little due diligence and see which of these sections are actually tailored to your specific case or your specific circumstances to be able to get the remedy that you're seeking. According to UCC 9626, action in which deficiency or surplus is an issue, applicable rules if amount of deficiency or surplus is or surplus an issue. And I just want to say this really quick. Everything that I'm giving you is directly from the Uniform Commercial Code. So this information is very highly accessible for everyone. It's just I break it down so that you can go pinpoint what you need. So just to clear that up, I'm giving you guys everything you need to be successful. You just still have to do the work. Like everything cannot be literally handed down or done for you because one, no one's going to do it like you would do for yourself. And two, you cannot expect everything to be done for you in this life. You have to put in some work where you want benefits or you want, or you're trying to reach specific goals that are going to help you in your future. You still have to put in some type of footwork. But all of the information I'm giving you is giving you more than enough for you to go and figure out which route you want to take to go seek the remedy for your repossession. In an action arising from a transaction other than a consumer transaction in which the amount of a deficiency or surplus is an issue, the following rules apply. One, a secure party need not prove compliance with the provisions of this part relating to collection, enforcement, disposition, or acceptance unless the debtor or secondary obligor places the secure party's compliance an issue. Two, if the secure party's compliance is placed in issue, the secure party has the burden of establishing that the collection, enforcement, disposition, or acceptance was conducted in accordance with this part. Three, except as otherwise provided in section 9 to 628, if a secured party fails to prove that the collection, enforcement, disposition, or acceptance was conducted in accordance with the provisions of this part relating to collection, enforcement, disposition, or acceptance, liability of the debtor or a secondary obligor my bad, y'all. I just removed that person because that's just rude. So we're gonna get back into it. The sum of the secured obligation expenses and attorney fees exceeds the greater of A, the proceeds of the collection, enforcement, disposition, or acceptance, or B, the amount of proceeds that would have been realized had the non-complying secured party proceeded in accordance with the provisions of this part relating to collection, enforcement, dispositions, or acceptance. 4, for purposes of paragraph 3B, the amount of proceeds that would have been realized is equal to the sum of the secured obligation expenses or attorney's fees, unless the secured party proves that the amount is less than the sum. 5, if a deficiency or surplus is calculated under section 9615F, the debtor or obligor has the burden of establishing that the amount of proceeds of the disposition is significantly below the range of prices that a complying disposition to a person other than the secured party, a person related to the secured party, or a secondary obligor would have brought. B, non-consumer transactions, no interference. The limitation of the rules in subsection A to transactions other than consumer transactions is intended to leave to the court the determination of proper rules in consumer transactions. The court may not interfere from that limitation, the nature of the proper rule in consumer transactions, and may continue to apply established approaches. Now you can get the car back and hold them accountable. And that concludes the end of this slideshow. I hope this information was very valuable. Like I said to you guys, I shared with you more than enough information for you to be able to go in and choose what method you would like to take or what code you would like to attack for your specific circumstances so that you can get the remedy that you need for your repossession. Repossessions are most likely done illegally because they don't normally send us the pre-sale letter. They don't normally send us the pre-sale letter. They don't normally give us a post-sale letter. They don't normally give us any type of notification of the the repossession that should be taking place. Because like I said, when they go through the repossession process, they employ a third-party towing company to do the job. Once they hand that responsibility over to that third-party towing company, that third-party towing company pretty much takes over and does things the way they see fit. So a lot of times they are going against your rights. They are violating your rights according to how they are supposed to be operating as a business that is governed under Uniform Commercial Code. They know we don't know this information, so they do what they've been doing for years, which is illegal practices. So we've been violated on a grand scale, not only just from us being duped into signing these birth certificates, but all the way down to us signing these everyday contracts for collateral that we need to get around or to be able to survive in everyday life in this world. And, they get us by having us sign contracts that lock us into obligations that we really are not responsible or even liable for repaying. So all of this goes together. And every class that I give, I teach more information for you guys to be able to use for your own personal life so that you can not only hold these companies accountable, but also so that you can live freely and build generational wealth. Now, in the event that you can't get the car back because they sold it and now someone else is the owner, all they would do is cut you a check for the amount of the car. So you could literally go buy a new car if you wanted to. I am personally going through this process myself with Bridgecrest Financial, because what happened to me was, first of all, my contract was fraudulent as hell. So I went through the rescission process, and in the midst of me doing the rescission process, they illegally repoed my car. So because of that, I am literally going through all of this Uniform Commercial Code and actually putting in the work for me to get the remedy that I need. So I share everything that I personally done myself. I share everything that I've personally experienced myself. I don't give you information from other sources because I don't have personal experience with other source information. I only give you what I know. I have a car rescission class for anyone who's interested in that, but in my honest opinion, car rescission works best when before the car is repoed and if the car is 3 years or younger and the contract is 3 years or younger. If it is 3 years or older, then going through this process, and if it's already been repoed, going through this process is better for you. Also, like I said, repossessions don't only pertain to cars, it also pertains to property, loans, and all type of stuff, equipment loans, and all that type of stuff. So use this information not just for repossession, but this information can be used for a variety of things because they also illegally foreclose homes, right? A lot of people are going through illegal foreclosures. All you have to do is just do the necessary work with the information that I gave you, and you can literally get remedy for any of these things shared in this video by any of the companies who are violating Uniform Commercial Code. So I hope that makes sense. I hope I really broke that down to you guys. And I want to thank you all for attending today. I have a trust class coming up on January 20th. It's a 4-part class. Each week, you'll be learning different layers of what a trust is about and how to establish it from A to B, and even how to fund it. If you're interested in that and you're in the community, you know how to get the ticket. If you would like to join the community, like I said, patreon.com /Divine Trust Babies, DIVINETRUSTBABIES. You can go on that website and you can join for $10 a month. The private community, all of the information, I share so much information there. It is way worth way more than $10. If you want to keep up with my teachings, that's how you can join my community. Other than that, follow me on Eventbrite so that you can see the next events that I'll be having. But to really be locked in, joining the community is the best thing you could do. Now, I want to thank you guys for being here on a Saturday morning, giving me your attention, giving me your energy and your time. Go study the Uniform Commercial Code and apply everything from this video to your life. Thank you again. I appreciate you guys. I'll see you at the next event. Before you go, I see some people left already. Before you guys go, I just wanted to reiterate that the replay will be emailed out to anybody who purchased a course at full price on November 20th. And if you wanted to get the replay, and you got a free ticket or you got what's it called? A discounted ticket, then that will be available for sale, 50% off on November 20th. Another thing too, um, I will always do my classes like this, so I will always have like a regular price. I'm trying to do like a donation thing, and it's donation based. So basically, if you whatever you're able to afford, and then I always will give out a few free tickets because I know everybody is not always in a position, when things change in people's life. So I will always give out a few free tickets for my event. Now, for the trust event, because you guys have stayed, the 15 of you have stayed and y'all ain't leave. If you don't have my email, I'm gonna put it in the chat. I want you to send me an email, and I'm going to give you guys a free ticket to the trust. It's the first part of the 4-part trust class. I'm giving y'all a free ticket to the first part because y'all stayed. So let me put my email in there. I just like doing this kind of stuff, so I'm always gonna have giveaways. And then y'all send me an email. Let me know that you are one of the 15. So just say one of 15 trust class, and I will send you the registration link for you guys to register or get y'all tickets for free. Again, I already thanked you. I can't thank you enough. If you are in Patreon or Divine Trust Babies Academy, I'll see you guys on Sunday, which is tomorrow, and I'll be teaching you guys how to obtain your passport for free. And it's not only if you get government benefits. So it's for anybody who can prove a hardship, a financial hardship. And the requirements are very easy. So I'm going to go through that entire process with you guys. So go ahead and grab my email. Send me an email. Let me know that you're one of the 15. And put trust class. And I got you guys. I'm going to send you over the link for you guys to get in that class. Again, I appreciate you guys. If you're not in a Telegram group, I emailed you. Go look for your email and check that and join the group. It's invite only, and it's a private group, so you're not gonna be able to search it. It's only by that link. So check your emails if you're a Divine Trust Baby learner, Academy learner, and if you're on Patreon, look on Patreon for that link. Enjoy the rest of your weekends, well, the rest of your day, and I'll see you guys on Sunday.